Yeah. So we will start now, sir.
Yeah. Yes.
Good morning, friends. Welcome back to the fourth day of this IBC refresher course for examination. Today we have CS Haribabu Tota, who is from Bangalore. Good morning, sir. Thank you
Good
very,
morning,
very
madam.
much for accepting our invitation.
Yeah.
This is his debut session in SARC, so hopefully he would be able to come and share his knowledge with us in other topics and on better conditions where you can come physically also.
Yeah.
Thank you very much, sir, once again for accepting our invite. Friends, as you all know, we have structured this program in such a way that if you attend this and you go through the code, the regulations, the rules, and the other acts to a certain extent, which all of us will have a little bit of knowledge about, but only thing we'll have to brush up our knowledge and see everything from the perspective of the code. It's actually very easy to clear this examination, provided we attempt the examination again in a very structured manner, like how I told you what you know, what you don't know, and what you are doubtful about. Always the first thing which should be at the back of your mind is the negative marking. Do not attempt any questions pertaining to the negative marking. Try to take up the exam as soon as these classes are over, maybe within a week or 10 days or max a month. Go through all the question papers which are there on the various websites. Go through the sample question papers in the IBBI website. Also go through the code, the act, the regulations, and you can face the exam very confidently, because we have ensured that this is a very exam oriented preparation which is happening. So we have Haribabu sir, who is going to talk about all the other regulations which were not covered. Sir, we have covered CIRP and liquidation regulations.
Okay, ma'am.
So it is all the rest of the regulations which you have to cover. Maybe touch upon the code of ethics.
Yes.
Because there are going to be case studies, and in case you can actually share, what type of questions will come in code of ethics, how people can go through the disciplinary cases which are there on the IBBI website, based on which, a lot of questions will be coming in the exam, the AFA requirement, and then the other requirements as per the disciplinary cases which are on the website. Friends, you should understand that all these cases, whatever is being disciplinary action is being taken on the members.
Yes.
For non-compliance of code of ethics is generally there on the website of IBBI. Sir will take you through that. Go through all the cases. You will be able to go through the cases which is before 31/12/2020, because that is what is going to be the syllabus for our examination. If you go through that, you will find it very simple to actually clear the examination. It is like CA, and I would say to a certain extent even CS. We are always conditioned to think that our professional exams are tough, but as you know, and exams do need to be tough. We are going to practice it in IBC more so, because if you see, it affects the economy as a whole, stakeholders, the recovery by the bankers. And also, there is a lot of disciplinary mechanisms which are, being initiated against the RPs. We don't want to tell you anything negative about what are the disciplinary mechanisms, but we should all understand that we are being watched by IBBI and the IPAs, because there are a lot of disclosures which need to be done. Sir will be going through all the disclosures which are required. What are the regulations which the IPs are bound by? So if you go through whatever, listen intently to whatever sir is going to say and mark it out on your notes, it's going to be very easy to clear the exam. I will just give you a brief introduction to Haribabu sir, and then we can go take off. CS Haribabu Tota is a member of the Institute of Company Secretaries of India and an insolvency professional under the IBC, and has more than 19 years of experience in corporate secretarial and resolution of stressed asset matters. He was one of the key secretarial members in the GMR group, and in a span of 12 years at the GMR group, he led and was a key team player in the GMR Infrastructure Limited's IPO, listing compliances, private placement, debt listing, fundraising, corporate restructuring, transactional compliances, appearances before the company law board, SEBI, RBI, and RD. He was the past chairman of the Bangalore chapter of the Southern India Regional Council of ICSI in the year 2016. And as a resolution professional under IBC, till date, he has revived 4 corporates and has an immense experience in IBC related matters, including appearance before the NCLT and NCLAT throughout the country. He is also a speaker at seminars of all professional institutes, industry bodies, student training programs, and other forums. Thank you very much, sir, for accepting our invite and graciously, accepting to share your knowledge and experience with us. Friends, the amount of experience he has as a professional is huge, and any queries that you may have, you can also get it clarified from him. Over to you, sir. Thank you very much.
Thank you, Revati madam, for excellent introduction, and good morning to you all. And first of all, I congratulate for deciding to be an insolvency professionals, which is a budding profession along with our traditional professional courses. So this being the new era of this thing where government experimented on the restructuring of businesses and resolution of stressed assets. So this law is a culmination of 11 legislations, and which has been effective from 1st December 2016. So far it is proved as a great game changer, but this one, however, as the progressively we see from the day one of the practice of into the IBC area, where increasingly insolvency professionals are subjected to intensive scrutiny regarding the conduct, and this is the going to be the role model for other professional institutes, the way they see the conduct of the professionals as far as their practice is concerned. And there is another thing that we need to keep it in mind. Till now, we are in compliance era of discharging our duties, and as this is associated with the resolution, and financially we are impacting every stakeholder associated with the society, be it in the country and be it in the corporate debtors and its stakeholders. So all the more we should discharge our duties with utmost care and transparency, and this one with an integrity. That's what the IBC professional envisages the professionals as a insolvency professionals conduct is concerned. And if you see that as a professional, if you are fully, this is not in a compliance role, particularly as if you see this as an insolvency professional, you have to discharge your duties. A promoter will have to comply the applicable laws, but he will have the freedom of running an organization. But as an insolvency professional, you will be stepping into the shoes of the promoter, where he is financially it is not functioning, or financially it is stressed out. So within the framework of law, and you need to be a professional to run the organization, so that ensure to all the stakeholders get maximum value in realization, be it in the form of a resolution plan, or if it goes for if it is not possible for revival, and if it goes for liquidation, realization. So that being the case, today, as you have also heard relating to the corporate insolvency resolution process, regulations and liquidation process, and this thing, today we will be dwelling upon this broadly on the IBBA and IPA and the IPs and the case laws relating to the IPs disciplinary actions. And further, during the course, over a period of time, a lot of forms have been introduced for reporting, timely reporting at each and every stage, which is also creating a concern and more stress probably at this moment as a resolution professional, which I am handling from 2017 onwards. So we need to have a dedicated team. And here another important aspect is technology is being put for intensely, on our role and on our conduct. So that being the thing, even IPA requires each and every notice that we are circulating to the COC, be it to the minutes, everything we need to upload it there, and every disclosures relating to the relationship that you are having with the corporate debtor or with the committee of creditors, and with you, whomever you are engaging, their relations with all the stakeholders, everything, it has been put on our shoulders to disclose and to ensure the transparency. This being the background, I would like to introduce the 4 pillars of the resolution process that is envisaged in the IBC to you. And we will take every 30 minutes one break, or if you raise it, so that we can meanwhile we will deliberate on the issues that you are having in your mind when seeking clarification. If you see the pillars of IBC, this is a main thing. If you see is the objective of the IBC is resolution of stressed assets and bad loan resolution. That being the case, how the insolvency and bankruptcy code envisages and the intermediaries that it look out is, first thing is, this is the Insolvency and Bankruptcy Board of India. And other pillar is this information utilities. We will dwell upon about information utilities in detail and how it is evolving over a period of time also. And the adjudicating authorities, and the insolvency professionals and insolvency professional agencies. These are the 4 intermediaries that is envisaged through which objects of the Insolvency and Bankruptcy Code, that aiming for. These are the mechanisms that has been devised on this Insolvency and Bankruptcy Board of India. So when the IBC started during the 2017, our ease of business ranking was 135. Now alone, because of this IBC implementation alone, has contributed about 35 to 40 points, and now currently our ease of banking business ranking is 52 in the index. So if you see what is covered under IBC, just I am briefing before going to this, so that as a recap you will understand. IBC deals with the insolvency resolution of individuals, LLPs, partnership firms, corporates, and corporate guarantors, and the liquidation relating to the LLPs and corporates, and voluntary liquidation of LLPs and corporates, and bankruptcy that is relating to the individuals and partnerships. If you see in all these 4 parameters, this bankruptcy resolution process insolvency and resolution process and bankruptcy process relating to the individuals and partnerships are yet to be notified, though regulations, everything is in place. This is the coverage of IBC. If you see in a nutshell, it is divided into 5 parts. That is, part 1 deals with the preliminary, that is section 1 to section 3. And the part 2 deals with the insolvency resolution and the liquidation of the corporate persons. Here, corporate persons, that includes LLPs and companies at this moment. Here it covers about CARP, that is corporate insolvency resolution process, liquidation, and pre-pack insolvency resolution process, and fast-track insolvency resolution process, voluntary liquidation, and adjudicating authorities. That is up to section 77. And here part 3 that deals with insolvency resolution and the for individuals and partnership firms, that will deal with the section 78 to 1, which is yet to be notified. And part 4 is mainly relating to the regulation of insolvency professionals and agencies and information utilities. And part 5 is relating to the miscellaneous provisions, which is mainly containing about carried about various amendments and effect of the overriding effect of the IBC, and how this for relaxation to the this one MSMEs for submission of resolution plans. And it is having 11 schedules, mainly amendment to the different legislations, and the 12th schedule is for, in relation to the class D of section 29A, where it prescribes the eligibility criteria for the resolution applicant. This is in just about the IBC. Here, if you see in brief, just I want to mention to you this how the corporate insolvency resolution process goes on. Here, the commencement of CARP will be commencing on admission of the application by the NCLT, and committee of creditors will assume the supervisory role here. Then, after commencement of the CARP, NCLT will declare the moratorium till the completion of the CARP, and CARP shall be completed within 180 days from the commencement of the CARP. And if not, with even during the period of CARP also, under section 12A, you can the corporate debtor or promoters of the corporate debtor, with the approval of the committee of creditors by 90%, they can withdraw the you can come out of this CARP process. And subject to the section 12.2, this one NCLT may extend for a period of not exceeding 90 days. Beyond the 180 days, it is at only once. And here the resolution applicant, after expression of interest, he will submit the resolution plan to the resolution professional. He will do the due diligence, and with his report, he will submit to the committee of creditors for approval, which requires 66%. The resolution professional shall submit to the COC, and after COC approval, it will be submitted to the committee of creditors, which with the approval of NCLT, it will be approved as a resolution plan, and corporate debtor will be revived. Otherwise, what will happen? It will go for the liquidation process. That is what, in brief, all about CARP process is concerned. If you see the corporate insolvency resolution process stage, there it is for 3 stages. One is admission of application stage. Here the sections 7, 8, and 10 they place the matter, and of course the specific Evidence Act, Limitation Act, all allied laws that comes into place, and equity of justice, though it is not envisaged in the IBC Act as a part of natural justice and giving opportunity to the corporate debtors, it will be provided. And though it is within 15 to 20 days, it has to be completed, but at times it takes even 6 months to 1 year also. Then the second stage is relating to the interim resolution professional, that is for a 30 days period, and the appointment of RP and IRP, which will be 180 days plus 30 days, that is 270 days it has to be. And here the third stage will be the approval of resolution plan. If it is approved, it will go for a revival of the corporate debtor, and if it is not, it will go for liquidation. If litigations exist, then the total period shall be 180 days. So this is the broadly the process how it will be dealt by. In the first stage is before the admission, and 2 stages is, one is the second stage is CARP, carrying of the CARP, and the third stage is post approval, either dissolution or CARP's completion is over, then either it will be revived or it will be going for liquidation. As so many litigations were there, it was extended for litigations are existing, means the 330 days. If you see the adjudication process and regulatory mechanism under the IBC, this is how it is placed. For individuals and partnership firms, it is debt recovery tribunals is the primary stage of the mechanism adjudication process. And if anybody is grieved, then it will be second stage will be the debt recovery appellate tribunals. Then it is the Supreme Court of India. Then, whereas in case of LLPs and corporates, if you see, it is the first stage is that National Company Law Tribunals. And the second stage is these national company law appellate tribunals. If you see the regulatory mechanism, that is the existing in IBBI. The first stage is the Insolvency and Bankruptcy Board of India. Then another important aspect which we have done, that is information utilities and insolvency professional agencies. Under that, insolvency professionals will, under the monitoring of the insolvency professional agencies, the insolvency professionals will function. And parallelly, insolvency professionals also are responsible to report to the Insolvency and Bankruptcy Board of India. And apart from that, there is another concept called this insolvency professional entities, where under register valuers also under the, though it is not stated under the IBC, they also report to the Insolvency and Bankruptcy Board of India. So the register valuers and organizations are formed under the this one under the Companies Act, but however at this moment they are under the control of the Insolvency and Bankruptcy Board of India. I'm giving the definition here just at the end, so that to understand at the end, I will tell you at the relevant time why I'm mentioning this relative definition. Here, insolvency professional, though he is from an IPE or member of the insolvency professional entity, he is individually, he will be functioning as the IRP, as an RP or a liquidator or bankruptcy. So hence the definition of relative is very much important in discharging our assignment, so that we can understand our role and engaging professionals and others. Here, if you see the relative, the term definition gives the reference to any person who is a member of the Hindu undivided family and immediate families, and it covers. So that is the wide coverage of the definition that relative assumes when compared to the Income Tax Act or Companies Act. Here and further, where the relation is that of a son, daughter, sister or brother, that is immediate relations, their spouses also shall be included as part of the relative definition. So when we are engaging or dealing in the assignments, we should be very careful about any of the relatives specified here coming into the performing or assisting any role, or any remuneration is being paid to them. If you see the related party definition under the IBC, here it is we being the insolvency professionals, we need to either our relatives should not be the directors and whom the firms are partners where we are engaging. So we should be very careful in engaging these people. And here this in the subsequent presentations, here in reference to the individual means he is any person is a relative of the individual or relative of the spouse of the individual. So here in the Companies Act, if you see, spouse relatives are not treated as individuals, but whereas in the IBC, even relatives of the spouse also is covered. And if we are partner of a limited liability partnership or partnership firm where the individual is a partner, and any person who is a trustee of the trustee, and if any private company in which the individual is a director and holds along with his individuals 2% of its share capital. If it is a public company, here it is an individual who holds along with the relatives more than 2% of its paid up capital. Here the relatives means, as I mentioned earlier, here all the relatives who are specified there collectively, it has to considered for considering this 2% of the paid up capital. And further, a body of corporate where the board of directors, managing director in the ordinary course of business acts in advice and directions of the instructions of the individuals, and a person on whose advice this is more or less relating to the definition of provided into the Companies Act and further under the Income Tax Act. So here whenever we are dealing with the relatives or related parties specified here, we should have prescribed disclosure mechanisms which we need to do it to the IPA. If you see the Insolvency and Bankruptcy Bank of Board of India, which is the first pillar in the IBC mechanism, here the provisions relating to the section 188 to 198 are applicable to the Insolvency and Bankruptcy Board of India, established on 1st October 2016 under the Insolvency Bankruptcy Code 2016. This is the instrumental mechanism which the first arm that was formed under the IBC after framing all the processes and mechanisms under the IBC, which is developing and taking care of the responsibility of the same. Here, the IBBA is responsible for implementation of the code that consolidates and amends the laws relating to the recognition, reorganization and insolvency resolution of corporate persons, partnership firms and individuals in a time-bound manner for maximization of the value of assets of such persons, to promote entrepreneurship, availability of credit, and balance the interest of all the stakeholders. If you see, this is also the objective of the IBC. So this is the main, as the regulated administrative entity, the objective of the IBBA also is the same as IBC, and it is a unique regulator which regulates the profession as well as the process as well. So here, this is the only regulator where this is discharging the double roles. And here it is also designated as an authority for the under the Companies Act, register values and valuation rules to them for regulation and development of the professional of the valuers. Here, if you see the Insolvency and Bankruptcy Board of India, here the chairperson is MS Sahu, and it is having whole-time members, part-time members, and invitees. Presently, these whole-time members are 3 members, that is Naurang Chaini and this one who is in charge for registration and monitoring wing, and Mr. Mukilita Vijayaraghvan, she is another whole-time member. She is in charge for administrative law wing, and Sudhakar Shukla, he is in charge for research and regulations wing. And here, apart from that, ex officio members are there who are from the Ministry of Finance, Ministry of Corporate Affairs, and Ministry of Law and Justice, and from RBI also. Here, further invitees who are functioning at the board of IBBA is part-time members who are the Chief Economic Advisor and the CEO of IDBI Bank, a former CEO of the IDBI Bank. And if you see the organization chart of the IBBA functioning, here mainly it functions in 3 verticals, that is research and regulation wing plus professional development. Here registration and monitoring wing plus legal affairs and establishment, and the administrative law wing and finance and accounts. Here the research and regulation wing provides the drafting of regulations relating to the IBC aspects, and time to time publication and data management and dissemination, and conducting of exams and knowledge management. And the registration and monitoring wing mainly is responsible for the functioning of all intermediaries and fixing the surveillance, investigation and grievance redressal systems and legal affairs. And the administrative law wing and finance and accounts mainly comprises of the functioning and overseeing and court proceedings relating to the IBBA. And apart from that, it is also having the committees which give advice on technical committee, advisory committee, and it is also having the board secretary strategy. This is the administrative mechanism of the IBBI board. So if you see the powers and functions of the board, which mainly dealt the under section 196, it is a responsible body for registration of IPAs, IPs, and IUs, and the registration of registration and withdrawal and suspend or cancellation of such registrations of all these intermediary arms. And it also is responsible for promoting the development and regulation of the working and practices of IPs, IPAs and IPs and IUs. And it is also the responsibility of it for specifying the regulation standards for the functions of all intermediaries. And it will also lay down the regulations and the curriculum for the examination. And friends, if you see, every 6 months the curriculum changes, and here it is also responsible for carrying out inspections and investigations on the IPAs, IPs and IUs, and passing of code orders for compliance of the provisions of this code, and monitoring of the performance of all intermediaries. And it can also have the authority of calling for information and records by the IPAs and IUs. And it will also is responsible for publishing information, data, and research studies and other information as may be specified under the regulations from time to time, and specify relating to the regulations. And it is also responsible for constituting committees as may be as laid down in section 197. If you see the section 197, there are 3 committees, that is disciplinary committee, advisory committee, and the technology committee, that are all existing at this moment. And it is also responsible for promoting the transparency and best practices in its governance and maintenance of websites and accessible repositories and electronic information. And it can also have the authority to enter into memorandum of understanding with any other statutory authorities. And it is also responsible for issue of necessary guidelines as far as functioning of IPAs and IPs and IUs consent. It is also responsible for mechanism for redressal of grievances against the IPAs and IUs. And it is also developed the complaints filed against the mechanism for filing of addressal of grievances, and conduct the periodic study and research and audit of the functioning of the performance of the IPAs, and mechanisms for issuing the regulations and publication and consultative process for preparation of this one drafting of regulations and publishing of the same. Here further, it is also responsible for the model bylaws to be adopted by the insolvency professional agencies, which will provide for the standards of professional competence and standards for professional and ethic conduct, requirements for enrollment of persons as members, manner of granting membership, setting up of the governing board for internal governance and management, information required to be submitted by the members of IPA, specific classes of persons to whom services shall be provided at concession rates, and the grounds on which penalties may be levied by the members upon a fair and transfer mechanism for redressal of the members, the grounds under which it can address the members' issues, and the quantum of fee and procedure for enrollment of persons as members of insolvency professional agencies, manner of conducting examination for enrollment of insolvency professionals, and monitoring and reviewing of the working of the insolvency professionals, duties and other activities to be performed by the members, the manner of conducting disciplinary proceedings against the members and imposing penalties, the manner of list utilizing the amount received as penalty imposed against the insolvency professionals. These are the primary duties. If you see the IBBA that requested to that is tasked to perform the duties, but however, it is as this being the overseeing and administrative body, it will also from time to time direct, even though insolvency professional agencies at many times granted the memberships, they were the IBBA has finally rejected membership registration or increase directly levying the penalties while taking disciplinary actions. So far the IBBA is playing active role in discharging the whatever the otherwise it is to be discharged by the IPAs, and it is increasingly felt that IBBA is has become in a lighter vein. I'll tell you as a threatening mechanism in case of any negligence or laxity in discharging our duties, and it is a at this moment it's a stress of concern, but whoever discharging with some proper care, and last 3 years we are seeing, of course we have also received letters from IBBA on giving clarifications and explaining the rationality. It got dropped. Very few cases get reported where amount of negligence in conduct, or be it other malpractices that have been carried and serious, which was reported by other stakeholders, then only it will be considered very serious. Otherwise, as long as we are discharging our duties within the framework of law and complying of all applicable provisions in the process in time to time, and so I don't see any issue that we need to be concerned about this. And as far as this functions is concerned, this further IBBA is also vested with the same powers as are vested in a civil court under the Code of Civil Procedure. This is under section 196 subsection 3. While trying any suit in the following matters, that is, it can summon for discovery and production of books of accounts and other documents at such place and time. It can also summon and enforcing the attendance of persons and examining, and it can also inspect of any books, registers and other documents of any person at any place, and issuing of commissions for the witness of documents and providing information before it. So if you see, as we mentioned, adjudicating authorities as here when it came to the IBBA, here we have the three mechanisms as mentioned in the adjudicating mechanism, that is National Company Law Tribunals, National Company Law Appellate Tribunals, and the Supreme Court of India being the final one. So here I would like to mention about the National Company Law boards. At this moment there are 12 boards, and at places in Chennai and at many places in Chennai, Hyderabad, in southern region, and in Mumbai, Delhi and Kolkata, there are more benches have been created for speedy disposal of the cases that are filed. Here, as far as examination point of view, here I would like to quote some of the courts that relating to the powers of the adjudicating authorities in discharging their duties under IBBA. Here, the adjudicating authority in the case of embassy property development and in the state of Karnataka, it is stated that this is the Supreme Court decisions actually. The adjudicating authority and NCLT have jurisdiction to inquire into the questions of fraud. However, they would not have jurisdiction to adjudicate and upon disputes such as those arising under the Mines and Minerals Development and Regulation Act and the rules thereunder, especially when the disputes revolve around decisions of statutory quasi judicial authorities, which can be corrected only by way of judicial review of administrative action. Here, one way it is mentioned as that IBC has overriding effect on all the legislations, but this was the initial decision. Later on, it got changed, and at many times there were frictions, and if between the which legislation is superior, and so at times it has been proved that IBC is the ultimate authority, and accordingly adjudicating authorities can discharge relating to all aspects while resolving the issues. And here in the matter of another case where the State Bank of India and versus Mr. Ramakrishnan Iyer, here in this case, liquidation of both CDs and personal guarantors, the adjudicating authority for which shall be the NCLT having here jurisdictional of the NCLT will depend upon the where registered office of the corporate debtor, and wherever that NCLT where the CARP is initiated about the corporate debtor, anybody connected the guarantors of the corporate debtor also will be tried in the respective NCLT only. So here the proceeding pending, and further the pending against the CD under the code or conclusion of CARP process is pending, that doesn't absolve the lender or the initiation of guarantee procedure, this CARP process against the personal guarantors will not required to be wait until the conclusion of the CARP process. So both proceedings can be simultaneously commenced, and the initiation against the corporate debtor, corporate guarantor or personal guarantor can be initiated with the same NCLT where the CARP proceedings have been initiated in the jurisdictional registered office located NCLT. Here further in another case where here this is an exclusive jurisdiction which was provided to the NCLT, where under the IBC it is only the NCLTs that are authorized for initiating the accepting and continuing the proceedings against a CD covered under the code, and so which made it clear that no other forum has jurisdiction to entertain or dispose of such applications, as a result of which this is an established law where civil courts or other high courts don't have any jurisdiction over the matters relating to the IBC. It is exclusively, that is NCLT only, that is having the jurisdiction over the IBC proceedings. And here in another case which is laid down by the High Court of Bombay in Jutan India Private Limited and PSL Limited, it is stated that NCLT is not a court of subordinate to the High Court, and hence as prohibited by the provisions of Section 41 of the Specific Relief Act. No injunction can be granted by the High Court against a CD from institution of any NCLT proceedings in NCLT. So this establishes clearly that NCLTs are only have the authority under the IBC proceedings, and no other court or civil court can entertain any proceedings or any institution of any proceeding suits other than the NCLTs. Here, that being the adjudicating authorities, we will see that insolvency professional agencies. Here, the insolvency professional agencies are mainly of three are there. Here, this is regulated by the insolvency professional agencies regulations. Here, the three institutes are an insolvency professional agency shall be a company registered under Section 8, that is a non-profit organization. So here presently there are three institutes. The insolvency professional agencies mainly primarily is responsible for the monitoring of the members' performance, where we have seen that IBBA, that regulations, wherever it is relating to the members, it is delegated by virtue of this insolvency professional regulation, IPA regulations. The IBBA has delegated that authority to the insolvency professional agencies. And here, these are all responsible for conducting the training programs and collection of data from the insolvency professionals who are functioning as IRPs and RPs and liquidators. And insolvency professional agencies are also responsible for issuing of authorization for assignment. This authorization for assignments, I will tell you in deliberately when comes to the IP regulations. Here the mechanism for issuing of the such things, and here this so far the though insolvency professional agencies are tasked to provide the disciplinary committee and proceedings and carrying out against the members, it was till now it is in national stages, and evaluation is to that extent in case of IPAs is yet to be evolved, and so far the IBBA only is performing this role of vibrantly. Here further, if you see this, we will go to this information utilities. Here, dear professional colleagues, I would like to mention briefly in other ways also in our conduct of professional practice and how these information utilities are going to be impacted, and why it is created. This information utility concept, as per the BLRC, that is Banking Law Reforms Committee, it is envisaged a competitive industry of information utilities to hold the information about all firms at all times. When any CRP process or anything commences, with it is aimed at to provide the information that is undisputed and with the complete details available to all persons involved in the insolvency resolution process, and the address the source of delay. When as so far which we have seen that our litigations in the courts and present judicial mechanism which is taking years, which is the main thing for that is the documents that are available for resolving the disputes or proving the disputes. So far there was no effective mechanism as far as this is concerned. If you see the existing mechanisms that were in place before IBC era, it was civil and CRISIL, which are rating mechanisms, and the financial repository information only was being carried out, regarding the financial conduct. But whereas this information utilities are of a different nature, where any documentation that is executed in terms of the any borrowings or any trade dealings, so all this information relating to the trade dealing or commercial dealings or borrowing related dealings will be uploaded into this information utilities system, where it will be preserved, and the moment it is uploaded, then the lender will be intimating, this information utility will be intimating to the borrower, and borrower has to authenticate the same. Once it is authenticated, then the information relating to the borrowing is crystallized and documents in place, as the borrower is not disputing and the lender is not disputing. In the event of disputes, this referring this number or this retrieval of information that is stored in the information utilities will come to a handy, and it will help in resolving the dispute relating to the crystallization of amount or documents that have been executed. So it is the intermediary which is designed for this purpose. As far as this role is concerned, at this moment we have under the IBC, if it is if you see what is an information utility, it is a professional organization which will collect the financial information and which get authenticated by both the parties to the debt, and they store the same and provide access to all the stakeholders that include resolution professionals, creditors in the insolvency resolution process, so that all stakeholders can make decisions based on the same information and avoid any disputes relating to the information or documents relating to the debt. So it is also act as a related information agency which accept electronically and get authentication and maintain and provide access to the financial information to the persons. That persons includes that, that creditors, adjudicating authority, and persons who are having interest in the information. And presently, if you see the information utilities that are existing in the country, only that NESL, that is National E-Governance Services Limited, is the only IU in the country presently rendering these services. Though it is aimed at developing the competition, it is this is the only information utility that is existing. But however, over a period of time, it is providing a lot of services, even including the CRP process also it is providing the services, and it is also providing for electronic storage mechanism for the CARP process related documents and other sending of notices to the COC. Everything it is providing a platform even for sale of distressed assets as well. Here, the main objective of the information utility, it is an institution with multiple objectives. It is aimed at to provide undisputed information for initiation of insolvency process. IU serves as a credit and contract repository, and it also accepts the financial information from financial or operational creditors. And the financial information will also be authenticated by all the parties of the debt and stored as used as evidence in any legal process. Here, it is also designed as a two-way communication tool between the creditors and debtors for submission and authentication of information for recording their disputes. It is as documents and information, everything is stored in the with the information utility. It is a cost-effective tool relating to the security interest and default, and it is also responsible for submission of information to the Committee of Creditors and Insolvency Professional Agencies and IBBA and Adjudicating Authority. Here, the record of default under these provisions here presently, that along with the application in the beginning of the IBC era, there it was not compulsory to produce the record of default with the information utility. However, presently any application that is initiated by the financial creditor, or be it operational creditor, and be it the corporate applicants, the record of default that is recorded with the information utility is must, otherwise the application won't be accepted. If you see the record of default ingredients as part of the information utility registration, it will contain the parties connected to the debt and history of submissions made in the financial information, and information on debt and default, details of authenticated invitation, emails, and communications sent, and it is the authentication categorization. This is also having color codes. When a lender uploads the information relating to the borrowing, first the communication, it will be sent which will be in green, yellow, and red. If the first intimation will come and it in green color, within 15 days, if there is no objection that is coming, then it will be treated as approved, and the green color message will come in green color. And if we confirm, then the confirmation will come that having treating that green code as an acceptance of the debt. And the third one is that second one is that is yellow color, which borrower will suggest the corrections to that, and post which it will be approved. And if you are disputing, and if you raise a dispute, then it will be depicting the color red color, so which is very categorization, the movement, that mail that has come from the NESL, which can be identified at what stage and what exactly it is and all that. And here in all the authentication and documents relating to with the IU is with digital signature only, no physical document signing that will be there. Here, dear professional colleagues, I am mentioning everything in practical aspects. Then I will open up this regulations also, and I will do in further elaboration, so that once you understand the broader perspective, then we will go into details of the regulations, and which will I will address the same as and when it is this. Then presently, this is an informative thing where NESL provides that information utility that provides the services. It is the responsible under Regulation 38 of IBBA Information Utility Regulations. It is responsible for storing of information submitted by the insolvency professionals, and here he may submit the reports, registers, and minutes in respect of the any insolvency resolution, liquidation, and bankruptcy proceedings. Here, apart from this, it also offers data room for storage and invitation of resolution plans, evaluation plans, and marketplace for interim finance, platform for auction during the liquidation. So it provides all technology, all-in-one technology platform for all IBC activities that are envisaged under the while carrying out the various activities under the IBC. Here, information submitted by the IBC is stored by the record of default here in a safe storage and secured manner. So here retrieval is very easy, and it will also provide as insolvency professionals are responsible for storage of services for 8 years after completing the assignment. So presently we have engaged, and it is charging about 5,000 rupees for 5 MB, 5 GB for storage of 8 years period. So it is very economic in also while utilizing the NESL services for data retrieval and electronic storage of the data, which is one of the statutory regulation prescribed on the insolvency professionals. And apart from that, this is an academic of nature. Here, the NESL also is introducing the digital document execution system, where all contracts and all presently, I hope many are well versed with the incorporation of the companies which prescribes all everything is electronic filing, including the drafting of a memorandum and articles of association as well. In the same manner, here this IU also is developing a mechanism for execution of documents, where banks will pass the information to the NESL in a standard format, prepare the model borrowing document, and it will also collaborate with the Stockholding Corporation of India and other stamping e-stamp authorities, and it will get stamped. And the customer, after getting it stamped and everything, he will authenticate by putting an e-stamp certificate and e-Aadhaar using Aadhaar sign or digital signature. Then once it is provided electronically, it will be the banker will attest his DSC confirming all the stamp duty, everything executed, and automatically it will be at the NESL storage system relating to the borrowing as well as all documents connected to the borrowing is stored and retrieval as and when is required. So this is the progress that is in place, or future is envisaged as far as the functioning of NESL is concerned, apart from the IBC services. Here, friends, and other thing is offenses and penalties that are all presently, if you deal with the nature of offenses, that section 68 to 78, it deals with the offenses and penalties, where majority it is towards the officers of the corporate debtor who will be facing the penalties. Here, if you see the section 68, that is punishment for concealment of the property, and 69 that deals with the punishment for transactions and defrauding the creditors, and it is punishment for misconducting course of CARP. Here, whenever this we are providing here this offenses section is very important from the examination point of view. definitely 2 to 3 marks that will be appearing for this penalties. Here exactly they will ask what is the penalty and which section deals with it. And here falsification of books of accounts by any person of the corporate debtor. Here if you see here the who is responsible, it is posted on any person as far as the falsification of books of accounts. So here if you see the penalties also, here all the penalties are of imprisonment in nature, and fines are not less than 1 lakh and 1 crore rupees. Of course, we being professionals, we are not required to be here. It is all officers of the corporate debtor that are responsible for this non-compliances relating to this provisions. Here that is relating to the concealment of property and transactions for defrauding the creditors and misconduct in course of CARP, and for falsification of books of accounts of the corporate debtor. The next one is that is willful material omissions and statements relating to the affairs of the corporate debtor. If you see, insolvency professional is responsible for carrying out, examining the corporate conduct of the last 2 years before the commencement of the CARP. So here the in during the course and any misstatements or material omissions are there, the officers of the corporate debtor are responsible. And section 73, that is for false representations to the creditors. And here the punishment for contravention of moratorium or the resolution plan also, that is also the corporate debtor. Here if you see, one thing is common, that is imprisonment for all the things, for all the offenses that are stated here. It is very severe. Here these are all monetary and as well as imprisonment. If you see this section 75, that is punishment for false information furnished in application. That is, here the application is filed by the operational creditor, financial creditor. So any false information is furnished in application, he will also be fined not less than 1 lakh rupees to the extent of 1 crore rupees. This is not the corporate debtor side. And here punishment for non-disclosure of dispute or payment of debt by the operational creditor. Here this is another punishment. This is mainly to discourage the practice of numerous applications that fail to unnecessarily eliminate the wastage of time or creating the nuisance. Here operational creditor on any other person, here also fine, it is 1 lakh to 1 crore. Here while this section 77 applicability will be there in the case of section 10 application, here the punishment for providing false information in application made by the corporate debtor. So here the corporate debtor, here imprisonment not less than 3 years and up to 5 years, fines not less than 1 lakh and up to the 1 crore rupees. Here wherever that corporate debtor is involved, it is 3 to 5 years, and fines are not less than 1 lakh rupees to 1 crore. Whereas other than corporate debtor is involved in so blindly you can say that any provisions that relating to the corporate debtor means imprisonment is there, and any obstruction or providing any false information, any provision, that for monetary penalty will be 1 lakh rupees to 1 crore. So section 75 and 76 is once again relating to the applications, which is only excluding imprisonment and fines being the same 1 lakh rupees to 1 crore. And the section 77 is section 10 application, where the corporate debtor files, once again that 3 to 5 years imprisonment and 1 lakh to 1 crore. So here if you see the other thing, monetary penalties that can be imposed by an insolvency professional agencies, having seen that here these penalties will be imposed on the insolvency professionals, which recently came into effect from 18th July 2021. So from the examination point of view, yes, we don't require to have it to see Here, but however, we have to file the necessary forms. Now, this IBBA has issued this circular actually. Here it is covered. First aspect is this filing of returns, disclosures, or if it is inadequate, then the fine will be up to 1 lakh rupees or 25% of the fee, whichever is higher, subject to a minimum of 50,000. And where the by IP, if he accepts an assignment having conflict of interest with stakeholders, it is up to 2 lakh rupees, and 25% or 2 lakh or 1 lakh, whichever is higher. And in all places, majority of the places, minimum is 50,000 rupees. In few places, it is 1 lakh rupees. And the another thing is this maintenance of records properly relating to any of his assignments. Then rejection of claims without giving any proper reason while undertaking any assignment, or fails to exercise due diligence in claim verification. That is also 2 lakh rupee, 1 lakh rupees is the minimum fees. And here the failing to comply with the directions issued by the adjudicating authority or appellate tribunal, and outsourcing duty, his duties and obligations. Here you may get that confusion or the doubt on what is this, whether as an insolvency professional, whether I require to do every duty or not. Here it is not like so, because you should be the responsible while being the resolution professional or IRP or liquidator, but at the same time your team will be doing out, but you are the final responsible authority and it should go under your signature. It is mainly to ensure that whatever the activity that you are being carried out or your team is doing, that it is going under with your knowledge and with your notification, or without your instruction it is not going out. That is the main intention here, the outsource of his duties, which case laws I will be providing at a later point of time. Here, failing to appoint the registered valuers wherever required under the code or regulations made thereunder for conducting valuation, and supply the information called upon to comply the, if you fails the supplying of any information called by the IPA board or adjudicating authority or the appellate tribunal, or failing to make the any public announcement in the manner provided for under the regulations relating to the invitation for claims or invitation for resolution plans, other things. And further, here here further it is if you are failing to provide the notice relating to the meetings and fails to reject the resolution from eligible resolution applicants, and fails to take action in respect of preferential and undervalued fraudulent or extortionate transactions. Here all the one or this one minimum fine is of 1 lakh rupees, and it will be discretionary. Above 1 lakh rupees it will be discretionary, and up to the 25% of the fees. Here further, in enters into a contract or agreement with the professionals in an incomplete and improper manner, then also this fine is there. And contravention of any provisions of the bylaws or regulations that have been specified, if it is not provided anywhere, then also this penalty will be minimum of 50,000. It is provided like in the Companies Act, where no other place the penalty or fine is provided, then this will come into play. Here, when we come to the our resolution professionals that are IPs, here the thing is we need to be qualified and experienced, that is required to have to become a resolution professional. Here, an individual shall be eligible for registration if he has 10 years of experience as a CA, CS, CMA, and advocate enrolled with the Bar Council. Then he has a bachelor's degree with 10 years of experience in management after MBA, a 2-year PGDBA program. Here, if he is not a postgraduate, then it is 15 years of experience in management is required. And he should also pass the examination of limited insolvency examination within 12 months before the date of application. Suppose if you pass the examination and within 12 months you need to apply for application, otherwise the whatever exam you wrote and cleared the examination, that will go waste. So within 12 months you need to make an application for registration after passing the examination. And before applying for registration, one has to complete a pre-registration educational course as may be required by the board, which is equivalent to the 60 hours training. And here, if this is not specified, then there is other course introduced by the IBBA, which states that the national has completed national or graduate insolvency program. Here, no individual shall be eligible to be registered as an insolvency professional if he is a minor and he is not a person resident in India and does not have the qualification and experience as stipulated in regulation 519, which I will detail you when I'll put the regulations, and has convicted of an offense, contempt, and which imprisonment is less than 6 months and 5 years is not elapsed. And then if the imprisonment is more than 7 years, or then he is not at all eligible. Then he is an undischarged insolvent or has applied to be adjudicated as an insolvent, then also he is not eligible for registering as an insolvency professional. Then he is declared to be of unsound mind. Then this is the most important thing which we need to keep it in mind. And here he is not fit and proper person, integrity, reputation and character, absence of convictions and restraint orders, competence including financial solvency and net worth. Here, this is a very subjective criteria. I will tell you two case laws where here financial solvency also and net worth also will be considered for for registering you as an insolvency professional. So here, if you see in one of the case, the IPA has cleared it. While applying for registration, this resolution professional has suppressed the fact that several criminal proceedings under the provisions of the Indian Penal Code were pending before the criminal court against him. When he applied, the IBBA had cancelled the registration issued by the IPA and declared him as not fit and proper to hold office under Regulation 4 of IBBA IPA regulation. So here, all other aspects also shall be considered while issuing the registration to practice as an insolvency professional. In another case, a charge sheet has been filed against the applicant under Section 498 of the Indian Penal Code, subjecting woman to cruelty by husband relative. It is under Section 3 and Section 4 of the Dowry Prohibition Act. Penalty for wrong for giving and taking dowry, and penalty for demanding dowry respectively. Here, when this was disclosed, the IBBA has refused to grant registration under the fit and proper criteria. So, which was this is very thing. So at the time of enrolling you as an insolvency professional itself, the intense scrutiny will happen about your conduct and past performance and other aspects, whether that fit and proper criteria is very it is subjective in nature, and person to person it will vary, and case to case it will vary. So that is the important thing we need to keep it in mind. So when applying for eligibility to become as a resolution professional. Here, further, after completing the training programs and all that, this application for certificate of registration shall be made to the IPA, and IPA in turn will verify and it will be forwarding to the IBBA for registration, and IBBA will issue the grant the registration. So here post for eligible to practice as an insolvency professional, the fees to be paid is, every 5 years once we need to pay 10,000 rupees, and on yearly remuneration 0.25% on IP remuneration to be paid to the IBBA. This 5 years once, that is at the time of enrollment if you pay, then after 5 years you need to pay, but this 0.25% on IP remuneration is whatever during the year you have earned. Say about you have earned about 1 lakh rupees in a year, we need to pay about 2,500 rupees, that is 0.25% in a year, before 30th April of the succeeding financial year. And apart from this annual fees for the IPAs, we need to pay that 11,800 rupees at this moment. Initially it was 5,900, which has increased in last year and this current year. And apart from that, we, as per the regulations, we need to have a minimum 10 credit hours. Members, please note that this is apart from the, as a CA or company secretary, as a CMA, you have to get the credit hours. This is for to act as the insolvency professional, or to keep your certificate as this one a valid one to accept the assignments, though you are not having anything at this moment. So minimum 10 hours in each calendar year you need to get. Of course, there was some relaxation relating to this during the COVID period. Now I don't see going forward that relaxation will be there. So in a block of 3 years, we need to get 60 hours of CPE hours, that is continuous professional education. Presently the block is 2020 to 2022, first one, which is effective from 1st January 2020. So if you complain all these things, then plus during the on appointment as a resolution IRP, you need to propose the find the relationship of RP with the professionals associates engaged by him and her with the CD and its stakeholders. Then further, event-based disclosures also regularly you need to file on the assignments handled by the IRP or IP. Here once you file all these things, then only this authorization for assignment shall be obtained, will be issued, and you need to pay the fees, and you need to get the CP hours regularly every year, and a block of 3 years 60 hours, and you need to make disclosures wherever you are engaged any professional during the assignments, and whatever the assignments you are handling, regular and event-based disclosures you need to file on the assignments handled by you. And subject to compliance of all these aspects, that is fees, payment of fees, and getting CP hours and disclosures during the CRP process, and the people engaged by you are your relationship with the stakeholders of the corporate data. On satisfaction of the same, the authorization for assignment shall be obtained every year. That is, before 45 days before concluding the authorization for assignment valid, this will be issued for 1 year. And if you are 69 or 69.5 years, then it will be valid for 1 year, or 70 completion of 70 years, whichever is earlier, and it will be issued by the insolvency professional agencies. Otherwise, as an insolvency professional, you cannot provide your consent to act as an IRP, RP, or a liquidator. Here it will be valid if there is no fixed time frame for obtaining this authorization for assignments. Here, suppose for example, I have my AFA valid up to December 25. I need to apply before November, after November 5 onwards, before December 25, I need to get my authorization for assignments, and I need to provide all the data whatever they have asked. In fact, if you are handling 3-4 assignments, definitely you are bound to miss the forms here and there. So without rectifying it or completing it, you won't be issued the authorization for assignments. And here you should have this authorization for assignments when you are giving a consent before the acceptance of the assignment, or before the commencement of such assignment. You need to have the authorization for assignments. This is the conditions required for practicing as an insolvency professional. So who can become an interim resolution professional or resolution professional? Here, the insolvency professional and all partners and directors, and in case you are associated with any professional entity of which he is a partner or director, shall be eligible to be or independent of the corporate debtor. And independent of corporate debtor, how it is determined is, we are all aware about section 149, which determines the eligibility criteria to be appointed a person on the board of a company as an independent director. As an insolvency professional appointment for a corporate debtor also, it's not only you and your directors and with whom you are partnering with, they are also having meeting the criteria of for eligible to be appointed as independent director. So that is what the term independent of the corporate debtor is meant. So they all should, you as well as your partners or directors, if you are part of any IPE, so they will also be treated, they also have to satisfy the independent criteria of the corporate debtor, that is section 149 of the Companies Act. So as I mentioned, he will be considered as independent of the corporate debtor if eligible to be appointed as independent director under the Companies Act and not a related party of the corporate debtor. Further, he should not be an employee or proprietor or partner of a firm of auditors, statutory auditor or secretarial or cost auditor, or of a legal or consulting firm, and had any transaction amounting to 5% or more of the gross turnover in the last 3 financial years. So if you are part of any statutory auditor where their income is more than 5% of gross turnover, that is being getting from the corporate debtor in the last 3 financial years, then also you will not be treated as an independent, and you cannot act as a IRP or RP for a particular this one. Here some 4 messages. Here enrollment of lawyers is of 10 years so far. No bar registered as an IPA. Here they have come to the only to an existing 3 IPS. So presently it is only lawyers have not come forward, and management experience, they are depending upon the thing, they are registering with the with these 3 IPAs only, and so far there is no other IPA that has come for registration. Here here overall for understanding purpose, I am mentioning this section wise. Regulation wise, I will go through once again that regulation wise, and then you will easily understand. If I am referring that regulation in detail, then it will be difficult to understand, you will get confused. And as far as AFA is concerned, it is on the registration on obtaining the membership to act as a resolution professional only. This AFA is required, and once you grant the certificate of registration in the initially, I also feel the same, that it is not required. Why this practice is started means, here Here the problem is there was no mechanism of conducting, and there are a lot of allegations and grievances have come against the insolvency professionals, as a result of which this AFA concept has been introduced. Here in this process, what will happen is every year you need to do what are the assignments you are carrying out, you need to disclose it, and you need to comply all the filings, everything, and data providing for the IBBA and IPA. As a result, so that here it will act two way. One, you have to comply all the regulations, then only you can practice in the next year. As this is a financial legislation which dealing with various stakeholders, so that's why this AFA concept has been brought, which as a normal professional we are not coming under this. Yes, we will have definitely we can have a break, and you please let me know when we can have a we can reassemble, so that we can do. Mr. Shalvam. Hello.
Yeah, you can give a break for around 10 minutes, sir.
Okay, so then now it is 11:25. We will meet at 11:35, madam.
Yeah, 11:35 should be fine.
Okay, okay, thank you.
Yeah.
Hello.
Yeah, yes.
Just tell me, sir.
Yeah, okay. We will break for 10 minutes, then we will do it.
No, yes, sir.
Okay, thank you.
Sir, you're muted. Sir.
Hello.
Yes, sir. We can start, sir. We can
We
download
can
it.
start, no? Okay. Dear professional colleagues, as we have seen till now, the eligibility for practicing and this AFA and for registration. Now we see this disclosures on appointment as an IRP or RP during the process. Here, this disclosure shall be made to the insolvency professional agencies, and it has to be made within 3 days. That is on appointment. Here we need to make that relationship of the insolvency professional with the corporate debtor and with other professionals, register valuers, accountants, and legal professionals and other professionals appointed by him, and the financial creditors, the constitution of within on appointment within 3 days you need to disclose. And in relation to the financial creditors, on constitution of COC we need to disclose. And relating to the interim finance provider, the agreement with the interim finance provider entered within 3 days, that we need to do it. Then prospective resolution applicants, the moment we supply the information memorandum to the prospective resolution applicant, we need to disclose our relationship with the insolvency professional. Here, relationship in the sense here, as we said earlier, that we need to be independent of all these entities or professionals and stakeholders in engaging them. Here, be it for the independent corporate director, you should be independent and you should disclose within 3 days of appointment of your relationship. And other professionals, as and when you appoint them, you need to disclose the relationship with them. And on constitution of COC, then you need to disclose relationship with the financial creditors. On agreement with the interim finance provider, then you need to disclose your relationship with him. Then with the prospective resolution applicant, when you will finalize here, once we issue the final prospective resolution applicants, then the moment you issue information memorandum, you need to disclose your disclosure relating to this one relationship with him. Here, relationship of the insolvency professional with, if any relationship with any of the above comes to the notice or arises subsequently, disclosure shall be made within 3 days of such notice or arising. So here, at the time of appointment, you are not having any relationship, or during the course of assignment, if you get, then you need to disclose within 3 days of such notice, or you are getting aware or arising of that situation. Here, in addition to that, here earlier, that is the disclosures that you should make it to the all the stakeholders with the IPA. Here, these disclosures are relating to the insolvency professional disclosures relating to the associates or other corporate debtors that you are engaging. See, here the responsibility also is an insolvency professional only. You should ensure disclosure of the relationship if any of the other professionals engaged by the IRP and RP during this ERP process. Here, the relationships disclosure include, see, the resolution professional, the appointment of other professional, he has to submit his relationship with the resolution professional, and the other professional has to submit his relationship with the corporate debtor. And the on constitution of committee of creditors, the financial creditor has to disclose his relationship with the corporate debtor, and the interim finance provider has to provide his relationship with the corporate debtor and with the IRP, and the prospective resolution applicant also the supply of information memorandum to the prospective resolution applicant or 3 days of the appointment of the other professional, whichever is later. So here all other professionals, it is the responsibility of the IRP and RP to ensure that they disclose their relationship with the with you, that is the resolution professional, or with the corporate debtor and the committee of with the financial creditors, with the corporate debtor and prospective resolution applicant. The responsibility is casted on the IRP only to ensure that they disclose their interest with the corporate debtor. Here, if during the period at the time of appointment, if it is not there, and during the period, if they come to know, then at that point of time also you should ensure that other professionals that as an IRP and RP engage, that you need to disclose your interest or relationship with them. Here you may come to an understanding what is mean by relationship. Here, if you see the relationship, how it will be treated as, it is one or more of the 4 kinds of relationships which are described below, that it is mainly is IP or other professional has derived 5% or more of his total gross revenue in a year from professional services to the related party. That means who are people engaging there, or any other professional that whom the is engaged in this ERP process is a shareholder, director, or key managerial person or partner of the related party, and where a relative of the insolvency professional or other professional, as the case may be, has a relationship of kind A and B. See here, not only you are not only professional, you are engaging their relatives. That relatives here for this purpose, not the IBC relative definition, spouse, parents, parents of spouse, that means in-laws, sibling of self and spouse, and children also treated as relatives. So here, not only you, your relatives should not have, who are specified, should not be having their income source more than 5% in a year, or they should not be a shareholder, director, or key managerial personnel. And apart from you and your relatives, the professional whom you are engaging and their relatives also should not have income source like this. And this is your responsibility to ensure that they disclose the relationship to this extent. So here, an IP or other professional is a partner or director of a company, firm or LLP, such as IPE, registered valuer, the kind of A, B, C, or every partner or director of such company with the related party. So here, if you are an IPE or director or company, then in all the 3 categories, whatever that means, here we have seen first category is your revenue, then second category is yourself related in the capacity as a director, shareholder, and all that. Then the third category is your relatives who are specified there, and the D category is whomever you are partnering with, they and their relatives also should not have the relationship of which is breaching that independent of the corporate data. So these relationships on appointment from time to time, this is the responsibility of the IRP and RP to do it. Here till now we were doing this disclosures, but it is become stringent now. We need to be more careful of each and every appointment or every relationship that we are establishing or we come across in the CRP process. So here, appointment and role of IPs as IRPs. Here, the adjudicating authority shall appoint insolvency professional under the section on commencement of IBC under section 16, and the consent by the IRP be provided in the form 2 as under the section 16.5. And here, this is the case laws, and the RP don't have any adjudicating powers. It's only administrative powers as opposed to the quasi-judicial powers. It is in Swiss Ribbons case by the Supreme Court of India. And IRP and IP is a facilitator and manager of resolution process. So he is the person who protect the rights of all creditors and stakeholders. That is as per the Unigreen Global Private Limited. Here, as a IRP and RP, he is responsible for management of the affairs of the corporate debtor shall vest in the IRP. The powers of the board of directors are the partners if in case of an LLP shall stand suspended. The office and managers of the CD report to the IRP and provide access to the documents of the CD. And he has to prepare the list of with books of accounts and then invite the claims. And here he has to check on the preferential and fraudulent and undervalued transactions based on the records. And he has to examine if a resolution plan is in accordance with the compliance provided in the code. And he is also responsible for constituting the COC. And he is the primary responsibility to ensure that business as a going concern under the broad directions of the committee of creditors. And he has to monitor the assets and manage operations until RP is appointed. And here he should also the financial institutions, he can also demand information instructions from the CD and to furnish all the information relating to CD from the financial institutions. And RP can proceed to take charge of the properties, deal with them under the IBC for resolution purpose. Here, customs duty not paid by the CD, and hence customs confiscation of the property, and it adjudicating authority stated that IBC has overriding effect and RP can take over, and he has to follow the strict timelines. And relating to the powers and duties, the main provisions are relating to the section 18 and 25. That is to collect information relating to assets, operations of the CD, to assess the current financial position of the CD. And he is the responsible to collect the claims. Dear friends, the professional colleagues, here I would like to say here, collect the claims it is the best estimation. And during the CERP process, IRP, RP don't have the adjudicating powers. That is nothing but a crystallization of the claims, whereas in liquidation only, he has got that power. Here only at best he can estimate and he can collect the claims, and he has to put forward before the adjudicating authority, and then for be it in the information memorandum for furnishing it to the committee of creditors and disclosing the non-disclosure undertaking, and be it to the resolution applicant. He has to take control and custody of assets of the CD as recorded in the balance sheet. That includes tangible, intangible, including intellectual property, which is the most difficult task for an IP and IRP. Assets for which the CD has rights in foreign countries, control of assets not in possession of the CD. Here he has to file information with the information utility if needed. And he is also required to raise interim finance subject to the approval of the committee of creditors under section 28 of the CD. And he has to appoint accountants. He has the powers to appoint legal and other professionals in the manner as specified by the board. And he has to convene, and he has to chair all meetings of the COC, and he is the main responsible to conduct the same. And he has to maintain an updated list of claims, and he has to invite a prospective resolution applicant, that is PRAs, who fulfill criteria as may be laid down by the approval of COC, and other conditions as specified by the board for submission of the resolution plan. And here, prior to his appointment, in the conduct of affairs of the corporate debtor, he has to, under section 28, IRP and RP has to take prior approval relating to the voting of creditors. There are two standards for certain items which are specified under section 66. About 66% of the total voting share is required. and whereas in other cases it is 51%. And here the 66% mainly is under section 28, that is to raise interim finance and to create the security and to change the capital structure of the CD and record any change in ownership, and instructions to the financial institutions maintaining accounts of the CD, undertake any related party transaction, amendment of the constitutional documents, and delegation of authority to any other person, dispose of or permit the disposal of shares of any shareholder of the CD or their nominees to third parties. These are all required under section 28, approval of the COC. Here, this is these forms disclosures by IRP and RP during the CRP process. This is relating to the assignment that you are handling. First, we have seen at the time of appointment, you need to disclose proving your independence, be it for you and your relatives or the partners and directors, where in case of IPE, you are part of it. Apart from that, on appointment, on discharging of duties under section 18 and 28, this forms required to be filed relating to the assignments that are being handled by you. At this moment, it is for the CARP process only has been prescribed, whereas in case of liquidation, that we need to do the quarterly reports. That is, say for example, now we are in June to September quarter, where after completion of September, by October 15th, you need to file an update on the progress or activities you have carried out during the quarter in the liquidation. And the stringent disclosure requirements have been provided during the CRP process, whereas in the same kind of disclosure requirements under the liquidation process and the voluntary liquidation process also is expected very short span of time, which is under preparation. And here in these things, I will brief you about the forms which are required to be filed during the CRP process. This form IP1, that is within 3 days of signing of form 2 of the insolvency and bankruptcy application rules, or form A of the regulations, as the case may be, you need to do it. This form 2 is nothing but the consent to act as an IRP. So here, when you are providing the consent, the application here for the filing of the application with the adjudicating authority, you need to file. Whereas here, this information, you need to file this consent the moment you provide, you need to file the same within 3 days of signing the form 2, along with the application to the IBBI. You need to state entire information relating to the what it is, that what is the default that is being filed, whether it is section 7 application or 9 or 10, or who is filing it, and what is the amount of default, what are all the documents, entire application also you need to file it. So before you give the consent, you need to understand for whom you are giving, what is it, and ensure that you get the application, because there is a responsibility on you to file within 3 days on the IBBA portal relating to the assignment to which you are giving the consent. And IBBA portal, they prescribes including uploading the application also. So, and that should be, the form 2 is dated say about today, then within next 3 days you need to file the form. So one should ensure that entire application is ready, and before issuing form 2, you need to get ready entire application. If they send it and everything is ready, and if they are sure, and you should also be sure about filing the moment you issue form 2, then only you should date it and give it and get the application. Otherwise, you will be defaulting on this front. And at this moment, it is every month, it is 500 rupees additional fine is being charged. First 30 days, there is no penalty. That means first 3 days, there is no penalty. And if you are crossing that, then it will be 500 rupees penalty. And it is day wise also, in months wise also, in some cases it is changing. So you have given consent, then application is filed, and you got application is admitted. then within 5 days of admitting the application for initiation of CRP process, you need to file CRP1, that is form CRP1 form, for within 7 days of making the public announcement under section 13. This is the this is the first form in the CRP process. First one, you have given the consent, and suppose the IP form will also contain the dismissal and disposal particulars. Once you give the consent, you should also clearly follow up with whether it is getting disposed or whether it is not getting disposed or when it is getting disposed, because that disposal order also, it is a responsibility on you to upload the same. So for initially for public announcement, why we will make for invitation for inviting for submission of claims. So within 5 days of the commencement of CRP, normally it is 5 days of CRP. Matlab, here the moment you get the order in your hand, from that date you can specify within 5 days you need to publish, and you need to within 3 days you need to, and within publication of within 7 days of publication under section 13, you need to file the same with and in the CRP1 form. Then the CRP2 is within 7 days of confirmation replacement of IRP under section 22. See, as an IRP, your role is for a period of 30 days. And within 37 days, within 35 days, you need to have a 37 days, you need to constitute the COC and you need to conduct the COC meeting. And within conducting of that COC meeting, whether you are confirmed or replacement, or you are getting replaced, or you are coming in some other place, previously IRP is and you are getting appointed, you need to file CRP2 form. Whether if it is in confirmation, then here I would like to bring it to your notice. In some NCLTs, if COC approval is there, just an intimation to the NCLT will suffice. Say for example, that is in Chennai, the practice, and in Bangalore, it is on confirmation. Even the same person is confirmed as an RP also, you need to file an application. On getting the confirmation on NCLT by way of an order, then only you will be treated as an RP of the company, as in corporate debtor. So here, if you see that, until that you will be functioning as an IRP. I had last COVID season where even resolution plan approval also I have filed as an IRP. Because of COVID, I could not get that RP confirmation from the adjudicating authority. So in that scenario, there will be a friction of filing the CRP2. And if you are other than the IRP, then you need to file that on appointment of an IRP. Here, the moment you file cessation of confirmation as an RP, you need to file all the information relating to the previous IRP assignment, everything you need to do it. So that is relating to the CRP2. CRP3 is within 7 days of issuing of IM information memorandum to members of COC under the regulation 36 of CRP regulations, you need to file it. Here, this consists of all claims, information memorandum, asset details, and litigation issues and related party transactions, and who are the suspended board of directors, entire thing. Friends, here we need to keep it in mind from the day one. You need to tick it, and you need to keep all these things, information regularly. You need to file it. See, here there is no 30 days concept here in IBC, and there is no holiday concept in IBC, be it in anything that you take it in IBC process. So you need to get Saturday or last day is coming on Sunday. There is no exemption, nothing like that. You need to file it within 7 days, even whether it is a festival or holiday or whatever it is, you need to file it. So this is CRP3 is within 7 days you need to file from the date of issue of IM to the COC members. And CRP4 is relating to the after publication you have received claims and you got confirmed as an IRP, then you have prepared information memorandum and issued to the COC members. Then you will issue the with the approval, you will decide the evaluation matrix and criteria for the prospective resolution applicants, and then you will publish the Form G. Then any expression of interest is received, you will examine and you will finalize the issue the prospective resolution applicants. Then you will have to give time for 5 days to 10 days. And if anybody objects, then you have to give clarification, and final resolution prospective resolution applicants list you need to circulate and you need to intimate, post which you will be issuing the RFRP. That is, RFRP is nothing but a request for resolution plan. So you need to understand the distinction between the expression of interest and request for resolution plan. Expression of interest is just you will issue the, whoever is interested can submit their expression of interest. In the expression of interest stage, you will be evaluating, you will be assessing the capability, you will be prescribing in the COC, you will be prescribing the eligibility criteria, net worth or turnover, whether he from this, if suppose from agricultural industry means he is from agricultural industry, or like that, you will be fixing some criteria and norms. So whoever in support of that, if whoever submits that we are eligible, we will submit, and along with that disclosure forms, everything whatever prescribed, then they will be submitting expression of interest. Then after post receipt of expression of interest, as per the statutory requirement, 10 days time you have. Normally 2 to 3 days we will keep it. If it is a small CD, then we will finalize the provisional prospective resolution applicants. We will intimating them. Then another 5 days time will be provided to fixed period will be provided to examine, to provide their grievances if anything is there against the provisional prospective resolution applicants. Then if there is nothing, then once again after 5 days you will be issuing the prospective resolution applicants, and after issuing the prospective resolution applicants, simultaneously you will be issuing the request for resolution plan, which will mainly contain information memorandum, evaluation matrix, and the request for resolution plan will contain the in detail about the corporate data and litigation issues and the further matters relating to the financial stability and asset details. So entire detailed information will be containing. This will be issued on receipt of the non-disclosure undertaking from the prospective resolution applicant. On issuing of this RFRP, within 7 days you need to file this ARP 4. So why I have mentioned the entire process is, while filing this ARP, this information, entire thing you need to put it, even including the issue of notice also, when you have issued for considering this, that also need to be mentioned. That is the criticality in filing of these forms. Here so that's why it is very stringent monitoring of the system here. Without that you cannot fill up this form and file it. Then if you have to file and state a date, you need to have a record. And so that's why from the day one your clock ticks, and here there is no question of okay today we will do, tomorrow okay after some time we will do it. Here that is the process in IBC which will goes on. Then the CARP 5 is within 7 days of the approval or rejection of the resolution plan or issue of liquidation order has to be filed. So here the 5 is on issue of IRP, that is 4, CARP that is 4, and 5 is has to be filed within the approval or rejection of the resolution plan or issue of the order of the liquidation by the adjudicating authority. Here, and this is section CARP 6 is when you file here any preferential, undervalued and fraudulent or extortionate transaction, and there are specific major instances whenever it is happening, you need to state that is CARP 6. So here one is a preferential transaction, fraudulent and extortionate transactions. When you are raising interim finance, when you are this one, commencement of insolvency resolution process of guarantors of the CD. So not only CD, you need to have control over the whether anything is initiated against the guarantors of the CD also. Whenever there is extension of period of CRP and exclusion of time you have sought and you got it, then it is then premature closure of CRP, that is appeal statement and withdrawal. Here the thing is under section 12A, if the promoter or CD can come forward and with the approval of 90% of the committee of creditors, that is on commencement of CARP, they can prematurely, they can close and propose and with the approval of COC. And before constitution of COC also, if they settle and the applicant gives an unpicking and then with the consent of the applicant, he files withdrawal and with the based on that the IRP will file it. Then also if it is a premature closure of CARP, in that scenario also one need to file the CRP 6. Then request for liquidation before completion of CRP, that is under section 33, where it's stated that where if the committee of creditors determines there is no point in conducting CRP process and they feel that if the liquidation is better than continuing the CRP process to realize and to avoid the wastage of time. Normally with the disputed real estate cases, this happens, this situation arises. And the non-implementation of resolution plan also as approved by the adjudicating authority. Here our responsibility won't end with the approval of resolution plan. As a resolution professional during the process, you will also be appointed as a monitoring agency. So you have to see that all compliances that has been specified by the resolution plan by the resolution applicant being implemented and successfully completed. Even that failure of CARP also will resolution plan implementation also will result in required to be filed in a CARP 6. Then CRP 7 is first of all, this filing itself is a difficult and arduous task, and whenever there is a delay in filing of all that 6 forms, CRP 1, 2, 3, 4, 5, 6, and within if you are failing and not filing and delay is happening as specified in that forms are filing, then you need to file CRP 7. That is, if you are not making public announcement within 3 days, and if you are not making appointed this within 40 days of this one, RP is not appointed from the date of commencement of CARP, IM is not issued to the COC within 51 days of public announcement, then RFRP is not issued within 51 days of issue of IM, and CRP not completed within 180 days of the commencement of insolvency. Then recently one more form is introduced, that is CRP 8. That is the CRP 8 is required to be filed by all CRP process ongoing and commencing on or after 14th July 2021. This is the recent one. Here as per section 43, 45, 50 and 66, the resolution professional has to come to an opinion on the preferential, fraudulent and unfair and exorbitant transactions. If he is not coming to an opinion, or if he has come to an opinion, he has to what is the order, what it states, everything you need to do it. Here friends, you need to keep it in mind one thing. As an IRP, it is very difficult for you to understand immediately to take over and carrying on the actions that has been taken and the examination of last 2 years for transactions and getting cooperation from the CO, this promoters and existing management and committee of creditors. And then only you should have your team to examine and expertise to all these things, and you need to come to a determination on such transactions within 1/15th day from the date of commencement of the CRP process, and you should have filed an adjudicating authority. So this opinion need to be filed. If you file an opinion, then what action you have taken, what you have determined, that is the thing. And if you don't have the capability to opinion and prima facie on examination of balance sheet, if you get an opinion, then you will appoint the forensic auditor. Until that it comes, and you need to file an application, and then outcome of that you need to file in the CRP 8. So these are the things. So here, until the assignments shall be granted every year, that is, I'm telling you, relating to the AFA, shall be granted every year from the IPA only on payment of fees that I stated, and CPE credit hours you should get, and you should have disclosed all disclosures relating to the professionals you have engaged, and then you have filed every form in time and all these aspects. This is taken into consideration on the calendar year basis. So otherwise, if you, when you apply, then they will say you comply all these aspects, then subject to this only we will issue, and you need to comply, and then only AFA shall be issued, and that will be on the calendar year basis. So we have so far we have seen on the disclosure aspects, eligibility and appointment of IRP and RPs. Here, as an insolvency professionals, it is an IP regulations. The code of conduct has been provided. Here, it is mainly divided on the following aspects. The code of conduct is devised. It is on integrity and objectivity, and independence and impartiality, and professional competence, and representation of correct facts and correcting misapprehensions, and timelines you need to follow, and information management, and confidentiality you have to maintain during the your position, and occupation employability and restrictions, and remuneration and cost also should be minimum. Then gifts and hospitality also you should not understand, you should not accept, sorry. Here, if you see that first schedule of the IP regulations, it will contain the code of conduct. I have detailed all the 27 points that have been specified here. You should be honest, straightforward, and forthright in all your professional relationships. You should not misrepresent any facts or situations, and you should refrain from being involved in any action that would bring disrepute to the profession, which is a subjective matter. From case to case, it will vary. And you should act with objectivity in professional dealings, and what are the decisions that are made with should be, without the presence of any bias, conflict of interest, coercion, or undue influence on any party, whether directly or connected with the insolvency proceedings or not. You should disclose all details relating to the conflict of interest, that as I have mentioned earlier during the assignment. Here, either you or your relatives acquire directly or indirectly any of the assets of the debtor, or knowingly permit any relative to do so. Relative means, as I mentioned earlier, all those people. Then independence and impartiality. Here, you should maintain the complete independence in professional relationships, independent of external influences. In case where IP is dealing directly or indirectly with the assets of the debtor, you need to disclose the impairment of objectivity, independence, or impartiality in the liquidation or bankruptcy process, and the approval of the board also has to be obtained, unless you should not deal with the assets of the debtor. So he should not take up any assignment under the code if any of his relatives, partners, or directors of the IPE, of which he is a partner or director, in the of which he is a partner or not independent or related to the process. So if anybody, any of your relatives or partners or directors of IPE is connected with any CRP process, you should not take in any assignment as an IPE in that corporate data. So you should also disclose any existence of any pecuniary or personal relationship with any person, with any of the stakeholders entitled for distribution under Section 53 or Section 178. Section 53 is under the CRP process. If it goes for liquidation, that is a distribution mechanism, that is waterfall mechanism that is prescribed under the code. And 178 is relating to the bankruptcy process of the individuals and partnership firms. So if any pecuniary or personal relationship is there to the stakeholders who are entitled for distribution under Section 13, then also you need to declare the same to the applicant, the committee of creditors, and whoever is proposing for the appointment of you as an IP or bankruptcy. And you should also disclose, this is recent inclusion, whether you are an employee of the or has been in the panel of any financial creditor of the CD. Suppose now nationalized banks, they do the panelization before appointment of any person as in their panel for as an IP case, as an IRP and RP for initiation by them. So you need to disclose that aspect also in its website and to the IPA as well. And you should not influence decision or the work of the committee of creditors, other stakeholders, to make any undue or unlawful claims. Either it can be for yourself or related parties, or you should give not give any undue preference to any other persons, and shall not adopt any illegal or professional improper means to achieve any modified objectives. Here you should also have professional competence. What it means here, he must maintain and upgrade his professional knowledge and skills to render competent professional service. So that means that is where the CPE hours will come. So that is where it will be monitored. And here any interpretation of you also should be in the view of IBBA or IPA, should not be proved, and otherwise in many cases that happen. And the representation of correct facts and correcting misapprehensions. You must inform misapprehension or wrongful consideration of a fact of which he becomes aware, and at the earliest practicable time. And you must not conceal any material information, knowingly make or a misleading statement to the board. And timelines, must carefully plan his activities and promptly communicate with all stakeholders, and must not act with mollified or be negligent while performing his functions and duties. You must ensure communication to the stakeholders. So you don't consider that only issuing notices and conducting meetings is your role. Here notices, reports, updates, directions or clarifications, not only for the adjudicating authorities, COC you need to do, who are submit the claims you need to give, IPA to you have to give, IBBA you have to give, and you should also give to the all the stakeholders connected with the CD. All so you need to give the reports, and not only to the statutory information, as and when if anybody approaches you also you need to provide. And it should be simple, clear and easily understood. No language that will make difficult for a common person to understand. And you should ensure and maintain written contemporaneous records of any decision taken. So any decision you taken, you need to have the rationale for arriving the decisions. If any records are there, you need to have that. And you need to have the information and evidence in support of such decision. This shall be maintained so as to sufficiently enable when establishing the reasonable person to take the appropriate of decisions and the actions that you have taken. So one need to maintain this information, and whenever any decision is is taken, he should not make any private communication with any of the stakeholders unless required by the court and regulations thereunder, or as per the orders of the adjudicating authority. You should also appear, cooperate, and be available for inspections and investigations that is carried out by the board. It is or any person authorized by the board or the IPA in which he is enrolled. He should provide all information and records as may be required by the board or the IPA. He should also be available and provide information for any period of study, research, and audit. Here, this it is little getting stabilized, and normally this IBBA sends left and right information, and they demands immediately within 1 day or within by end of the day or within 2 days. This information required to be provided, like that mails we used to get, and this is what you should always be available to provide the information as a resolution professional, which is not the insolvency, which is not the case in our traditional professions. And you should also maintain the confidentiality of all times except with the consent of the relevant parties or required by law. And you should must refrain from accepting too many assignments if he is unlikely to be able to devote adequate time to each of his assignments. This is the most difficult thing to understand. Here, if you are accepting assignment, you need to able to spend adequate time, and if you have a team, then also there is a provision or a stipulation that you should not delegate your assignments. So you should get the work from the team, and you should also be responsible for planning and executing all the and carrying out all the assignments without any difficulty. You should not engage in any employment where so during the CERP he and his relatives shall not accept any employment other than an employment secured through open competitive requirement with or render professional services other than the services under the code. So post completion of the CERP, so either with the creditor who had having more than 10% voting share, or the successful resolution applicant, or the corporate debtor, or any of their related parties until a period of 1 year is elapsed from the date of cessation of such process. You should not have any relationship through in the form of any employment, either you or relatives, as I specified earlier. So you should also not engage any relatives or related parties relating to your assignment. And you shall not provide any service in connection with the assignment which is being undertaken by any of your relatives or related parties. So as an IPE, if it is indirectly compromising your thing, and you should not conduct business which in the opinion of the board is inconsistent. So you should also be careful about this in the where if you are acting as a sleeping partner of any business with any person, so this should also be monitored by the board. And as far as remuneration and cost is concerned, the remuneration which you are charging shall be in a transparent manner, and it should be a reasonable reflection of the work necessarily and properly undertaken, and this is not inconsistent with the applicable regulations. So you should also disclose the fee payable to you, the fee payable to the IPE, and the fee payable to professionals engaged by him. It has to be disclosed to the IPA, which he is a professional member, and the agency also shall publish such a disclosure on its website. So you should also not accept any fees, charges other than those which are disclosed and approved in the by the persons fixing the remuneration. You have to disclose all costs and ensure that such costs are at unreasonableness. So here the unreasonableness, how it will be arrived is, it is the case to case basis and depending upon the size of the corporate debtor. Here and the gifts and hospitality, here in IP or his relative must not accept gifts or hospitality which undermines or affects his independence as an IP. And further, he also shall not offer gifts or hospitality or a financial or other advantage to a public servant or any other person intending to obtain or retain work for himself or to retain an advantage in the conduct of a profession for himself. Friends, here this code of conduct is similar to our other professionals, traditional which we are doing, and it may impact whatever is judgment or order is passed or that has been found out of non-compliance of this code of conduct. Then it may, we don't know, so far we have not come across, this may result our in a regular membership as well. This is the code of conduct for IPs. And if you see the challenges, though it is not of this is an examination point of view, I would like to mention here, rush through it. So there is no time to develop an understanding of the business, and here cooperation from earlier management is critical. Which will take some time to keep the business operations smooth. And as this being the stressed assets and non-compliances will be plenty of in many cases, ensuring statutory compliances with the availability information is very difficult. And the timelines with the disclosure norms, it is very stiff actually, and management of the resolution process is very difficult, and addressing of conflicts and with the incomplete records, and strategizing a suitable resolution plan with the inputs and support of the COC. And where in case a large number of claims by creditors and verification of claims can come, is a time consuming process, and it is a very difficult thing. And you should also responsible that CRP costs in check and at various stages litigations are expected, be it admission of claims, be it constitution of COC, and be it conducting of your discharging your role, and being it finalizing the resolution applicant, and being it approval of the resolution plan. Multiple litigations are expected during the CRP process, and you should patiently wait for the outcome, and you should sail through that without any issues on your part, depicting negligence or non-application or other modes of in your conduct. And here ensuring that payments to employees and workmen of the series and again difficult task, and appointment of professionals and getting their discharge, their disclosures, and ensuring their independence. So in brief, we can say IRP should act as a CEO, Chief Executive Officer, and he should also be an expert in financial accounting practices, so that financially he can be fit. He has to perform as a role of CFO, and he is also he has the dexterity quality in handling the relationship with all the stakeholders. Then he should be also people's relationship officer, so PRO, and he should also be responsible for compliances of all applicable laws. So he should also be an CCO, Chief Compliance Officer. Then he should also report to IBBA, IPA, IA, and IP activities and promoters on activities and assignments. He is an information officer as well, and he should be an excellent in advocacy, so that he can conduct the meetings very well, appear before the NCLT, and then only he can perform. In short, I say IPs are to function as a supermans actually when carrying out their duties. It's a lighter vein. Just I want to bring it to the all the participants here. So here the procedure followed on contravention by IPs. This is a disciplinary mechanism. Here the 4 sections are carry out these provisions relating to the disciplinary mechanism. Under section 217, complaint shall be filed against IP, and section 218, it is an investigation by the board, and section 219, then after investigation the board shall issue the show cause notice, and under section 220 the disciplinary committee will be appointed, and it will thoroughly examine and it will pass the orders. So here so far it is discharged by the boards relating to the orders which has been passed, There is an IBBA website also as having grievance cell, where if you log into it, it will also have the you have to pay 1,000 rupees, then you can file and report against the IRP. The moment they raise any notice has been filed, then that notice shall be served on the IP. Even I also received some 2 notices, and on receipt of that, and if the extensively with an information, if you furnish the information and explanation and clarification for the notice raised or grievance raised by any party, then IBBI will examine it, and then it will, if there is no credibility in the allegation or grievance, that it will be closed at that matter. Then if there is no sufficient reason that is being provided by the IP, then board will investigate. That is the administrative monitoring department. So then they will investigate and they will issue the so cause notice, and then it will move to the disciplinary committee, and then they will address, then they will give the hearings opportunities, and it will be disposed of accordingly. Here under section 217, any person aggrieved can file a complaint to the board in the form prescribed. Under section 218, that investigation by the board on receipt of the complaint, it will investigate, and then it will order in writing direct any persons to act as an investigating authority to conduct inspection and investigation. It will be conducted in a time as specified in the regulations, and persons may be bound to produce documents, records, and information. It may enter the building place, and as a civil court powers, it has the authority to do it, and it can take its custody the books and registers, and detailed report of inspection or investigation shall be submitted to the board by the investigative authority. Then upon issuing, then under section 219, issue the show cause notice and carry out inspection of such IPA, IA, and IU, and this one, and time shall be provided for reply as specified under the regulations, and appointment of board shall constitute disciplinary committee to consider the reports of the investigating authority. So this DC shall constitute 2 whole-time members of the board. If the DC is satisfied with the, after giving the opportunity and providing the sufficient time frame for providing and hearing, it will impose the penalty or cancel the registration or suspended the IPA and IPIU. Friends, here I would like to bring it to your notice. If you see the Insolvency and Bankruptcy Board of India front page, as and when they decide, they will displace in the matter of so and so, it is disclosed, and you can see the orders also in mainly containing the non-compliances and malpractice, this one, and in some cases wherever it is genuine, they have issued with a warning and advisory also. And where that serious lapses are found out, then they will levy the penalties heavily on the resolution IPs as well. So normally these losses will be 3 times of the loss cost, the 3 times of unlawful gains not exceeding 1 crore, and discharge the amount equal or unlawful gains, restitution of persons who suffered loss. Here, I would like to mention here the recent orders that have been passed. Mainly is acting without proper authorization for assignment. During the transition phase, in many cases, many people have given consents without having the authorization for assignment. In that scenario, that IBBA has filed the levied a fine for professional misconduct, this 10,000 rupees, where this AFA, without AFA, acted as an RP. And in the following cases also, IBA had taken a stern view of the lapses of the IPs in obtaining authorization for assignments. Here, in all these cases, the punishment and fines were levied on the IPs. And here, in one of the case in Topper Steels and Private India. RP had provided consent in 2018. However, it was admitted, but he didn't get the AFA. But post admission, he got an AFA and requesting or this one pleading that consent was provided in 2018 and accepted without his knowledge, stating all those things. Then gave a warning and left him. And here in these following cases also has been given warnings at the time of acceptance for not having authorization for assignments. Here here in some of the cases where it was held that consent has been provided, or at the time of filing of the petition he has not having AFA, but he has got IFA on getting it, and the further it was as a transmission procession, it has given with a warning in the above cases. Here violation of specific cases. Here the RP had engaged a private firm, Duff and Phelps, as other professionals, and had subsequently taken an insurance policy for himself and the employees of Duff and Phelps, and assigned the benefits of the insurance policy to Duff and Phelps, paying the premium of the insurance policy from the CRP cost. Here you would know, here the RP has engaged this firm, which is not an IPE, and he has taken an insurance policy for himself and the employees of this firm he has engaged, and assigned the beneficiaries of the insurance policy to the Duff and Phelps, and treated that taking as that private firm as a CRP cost. So he is levied as 25% of fee payable to him as remuneration was ordered as a penalty. So and this has been published in the IBBA website as well. And in the case of Educom Infrastructure and School Limited, there it was the RP was violative of section 513. So however, for the said contravention, here the included the legal fees to the legal counsel engaged with COC under CRP cost. If you see, whatever for the CRP process if you are engaging, then that also it will be, that only it shall be treated as a CRP cost. Whatever the COC has engaged means that should be borne by the COC, and in this case it has been included. So with a warning it has been issued. In Bhushan and Power Steel Limited, here once again this is under the violation of section 513. Here the remuneration was ratified as 1.2 crore, whereas the fees for the ARP is 14.5 lakhs, and whereas for IPE it is 1.05 crore. So it is said the same was in violation of the 513 engaging, and it was so here it was multiple contraventions, penalty of rupees 29 lakhs to be deposited, reimbursement of 12 crore from the COC. Here in this case, as the RP has engaged the other firm, and so even COC cost also has been included, so it has passed the strict order for COC also to reimburse the entire COC cost also, which was put as an CRP cost. In the same case, here 12 crore was included as an CRP cost for the legal counsel of the COCs. So here that's why the IBBA has passed an order to repayment of that entire 12 crore rupees in the CRP order. Yeah, the presentation will be shared after, once I will make it with everybody for their understanding. And here IBBA also has directed the RP to deposit 29 lakhs, that is 10% of the fees payable to him, and reimbursement of 12 crore from the COC. Here in this matter, he has raised the services invoices for the services rendered by him. instead of his name in the name of his firm. So this also treated as an violation of section 513, which was stated as a directly he is entitled or to receive the fees, and it was held as contravention of the provisions, and it was passed that the RP shall not accept new assignments for the following 3 months. So here in this case, RP has filed an application for liquidation after the CRP period had lapsed. So within the CRP period, this liquidation application has to be filed, and during the CRP period had ended and before liquidation was ordered, he has conducted 2 meetings. That means post 180 days and before the liquidation order is passed, he held 2 COC meetings for this one held to take the decision. So in this case, as after post completion of CRP period, there is no authority for COC, and before the commencement of liquidation, he has conducted the COC meetings. He was levied 25% of the fee payable to him as penalty. And once again, it was order was passed to undergo the pre-registration course again. In Max of Tech case, this one he has paid dues to the CD which had incurred pre-CRP period. So it is includes here whoever professional services rendered, it will be treated as an operational creditor, and only RP is eligible, or he can pay whatever the expenses during the CRP period. Here in this case, it was paid before the CRP period, so he was fined with 25% of the fee of entitled by him as a this one penalty of his remuneration. Here in this case, once again, it was CD had availed the loan 75 crore from the financial creditor, and return had pledged the rental income to the financial creditor. And during the CRP process also, this financial creditor was also receiving the rental income. And the RP had stated that it is a commercial wisdom that the FC can take it. So it is as during the CARP, no payments, except for the carrying out the process or ensuring there's a going concern of the CD to be paid. So this being the payment of past dues or installments of the FC outstanding after submission of commencement of CARP. So this is not acceptable and treated as contravention under section 14, and 25% of fee of him is levied as a fine. And this case, the IRP has failed to identify and take control of the assets of the CD due to non-cooperation of the suspended board of directors. On failing the application for non-cooperation under section 19, he was treated and levied. A order has been passed that he should not file accept any assignment for the next 6 months. Here in this case, the RP took over the management of the CD. Subsequently, Honorable Supreme Court stayed the CRP order. During the interim stay granted by the SC, the RP had handed over the custody and control of the CD to the erstwhile management. And after, during the stay period, the preferential transactions have been carried out or had taken place as the RP had handed over the control and custody of the CD to the erstwhile management. Then after some time, the Supreme Court has lifted the stay of this ARP. Then once again, the RP has taken control of the CD by virtue of the same. So here the for the transactions that have been carried out, the RP has also filed an application under preferential, unfair, and fraudulent and extortionate transactions. So here it is treated as that he should not absolve the violation of under section 23, though he handed over a stay was there, and section 25 of the code. The RP shall not seek any new assignments for the next 6 months. So until it is completely disposed of by the NCLAT or Supreme Court, if any temporary stay is there, an RP should not hand over that the CD to the management, and you should continue. They will say we got the stay and everything, but you should have control over the CD. That is what this judgment is concerned. And in the matter of RRP Housing Private Limited, the Municipal Development Authority has sealed the office premises of the CD. He has filed an application and he got directions, and CMDA, that is Municipal Development Authority, has resealed. On the day of this one resealing, RP had failed to avail the opportunity. It was informed, and in the second time also RP nor his representatives were present, and it was treated as he has violated section 25 of the code. But no merits on other allegations has been found, and show cause notice was set aside. Here in this case, he has failed to take steps to reverse certain transactions, and he has failed to file a preferential, unfair, and fraudulent transactions case. He was inconsistent in maintaining the list of creditors of the CD, the amounts claimed by them, and the interest rate, and such other details under the IBC regulations. So he has failed as far as utilizing his powers under section 25, and he was suspended for 3 months. Here I will share the other case laws also here, where the contravention by the liquidator and the CRP process, where disciplinary in this case, disciplinary committee was held that the RP didn't act independently, nor did he discharge his duty undertaking due diligence for in relation to the appointments. So he should not take any new appointments for next 3 months, like that. It was the order is being passed. Here in this case, an order was passed by the adjudicating authority, and as due to these hearings, the IP didn't appear in person, and so in spite of directions by the adjudicating authority also, and the IP was levied a penalty of 20,000 as penalty. Here in RP had appointed IPE and had outsourced the obligation of verifying and collating claims of the creditors. So that's why here the IPE will do, but at the end you should only sign, you should only correspondence should go in your name, and hence it is an order, and 1 lakh rupees as penalty has been levied in this case because of his delegation of outsourcing the verifying and collating claims to the IPE. Here also this is outsourcing for preparation of information memorandum, where it is also violation of section 25, and it was given a strict warning. And here in the Gitanjali Gems case, the RP had outsourced the following to the which we have dealt, though it is not an IPE, for all these duties, and that's why he was levied a penalty of more than 1 crore, which is amounting to 25% of the fine. Here in this case also, here outsourcing of the works under the to the third parties, which is violative of section 25. So it has been once again passed to undergo the pre-registration course and penalty, and 3 months bar on accepting new assignments. So in one should we remember any support team cost on IP, he should raise in his name whatever he is eligible, and whatever the support team cost or anything IP is associated, then that should raise separately in his name, and otherwise it will be treated as non-compliance, and it will be treated as a retrospective effect, and serious penalty will be levied, and show cause notice was though it is in a initial phase, it happened in 2018 with a lighter penalty, and it has with a serious warning, it has disposed of the show cause notice, and he has to disclose the relationship of the professionals engaged by him to his IPA. In the instant matter, the RP had failed to disclose his relationship with an auditing firm in which the RP is a partner. So he was levied for 29 lakhs, and this is also once again Bhushan Power and Steel Limited only, which many of the cases, if you see, these are all in understanding of the bifurcation of clear work and responsibilities. So we should be very clear on delegation of this one handling and taking support while discharging your duties as an RP and IRP. So one should be careful about the handling in assignments and corresponding and engaging the services of professionals. Here in this matter, A has suspended directors, and earlier promoters did not cooperate. The RP also has filed an application for non-cooperation. Here, the RP has refused to appoint values and misrepresented the law that the cost of values is covered under, wherein the fact that the values need to be appointed even before the constitution of COC. This is in the initial phase where the responsibility of appointment of IRP, this one, values was on the CRP. So it was observed and imposed a penalty of 100% of fees payable to him actually. Here, this is a paper publication not to be, has to be made within 5 days, in which case he was not made after a delay of 8 months from the date of his appointment he made. So for which the fine was levied 1 lakh rupees. And in this case, he did not file the progress reports and appropriate applications, and with respect to the preferential, unfair, and fraudulent transactions, and that he was filed awaiting orders from the adjudicating authority based on his progress reports, and based on the instructions only I will file, like that he has stated before the IBBI. So it is stated that as 135 days is going on, it is stated that RP should file and he should have disclosed and taking actions under regulation 48, that is the timelines of CRP. And as he was not has done and failed to do so, it was ordered that he should not take any new assignments for the next 6 months. Here in the following matters, IBB has taken a lenient view, and though it was the non-adherence of the timeline specified, here determinant of publication of EOI due to settlement talks between the CD and sole member of the COC. So issuing of publication of EOI was delayed. So, but IBBA has taken a lenient view here, and here valuer was appointed, but valuer fee was not ratified by the COC and payment not made. So he has taken stated that valuation commence only after payment is made. So due to that also, here he could not complete the valuation exercise, and IBBA has taken a lenient view. And here the appointment of forensic auditor was delayed by 4 months, and because COC did not approve the fees payable to the forensic auditor, and IBB also has taken a lenient view relating to this. So here, in this case, the RP did not seek the approval, ratification of appointment as well as the fee of the valuers by the COC. Hence, the RP later admitted his technical lapse by not providing the fee of valuers for the approval ratification on the agenda. So here it was order was passed that he should not accept new assignments for 2 months. Here in this case, RP had failed to ratify his fee as a liquidator before the COC, and hence in violation of so before in the CRP process itself, it has to be the fee has for the liquidator has to be approved. So accordingly, it was treated as IBBA observed that due to the said contravention, so it was posted on him, and he was forced to deposit 31 lakhs and this penalty, which was the fee paid to him without the approval of the COC. The RP had executed 11 power of attorneys in favor of the auditing firm when he was appointed for providing advisory professional services. This act for execution of the power of attorney was not approved by the COC, and hence it was treated as a violation. So authorizing also it will be treated as a violation of section 28. So here IBB observed that RP has contravened section 28 of the IBC and having made multiple contraventions, no penalty, no new assignments for a period of 3 months. Here in this case, he has not got the approval from the COC for the payment of the fees for the auditor appointed for conducting the audit of the CD. So in this case, IBBA has warned the RP to be more diligent and careful in future such dealings. Here, appointment of unregistered valuers. In initial phase, the valuers was not required to be registered with the IBA. So then during the transition period, some IPs have appointed who are not registered with the IBBA. So they were all levied fines. Of course, that won't arise. This situation won't arise now. So the here in this case, appointed valuers who has not been registered with IBBA, and therefore it was passed order that he should not get any order for 2 to 3 months. Here in this case, the RP has suppressed the fact and several criminal proceedings under the Indian were pending before the criminal court. Here it is, as I mentioned here, it is for registration of the IP, which was not granted registration. Here once again in the Bhushan Power and Steel Limited, friends, this is an important one. This is Swiss Ribbons and Bhushan Power and Steel, where many issues have been dealt relating to the COC role and the other interpretations relating to the CARP. So I suggest you, if you time permit, both the cases in detail to go through it, so that it will be of important from your examination point of view. Here in WIG Associates also, the following violations were noted by the IBBA by the RP. What is that is invitation of EOI without the approval of COC, failing to publish the particulars of the invitation in Form G, and failed to submit the IBBA the copy of records of the proceedings before the AA. And here convened only one COC meeting with only one agenda to seek approval for extension of time. So here that there is no significant business, he has submitted that because of there is no significant business of the CD, he did not display, it was considered as didn't display any sincerity towards his duties, and thereby held as contravention of section 23. Here he has permitted a recovery plan to be considered as a resolution plan rather than the resolution plan under the section under the IBC provisions, which was treated as a violation of section 34. So one-time settlements cannot be considered as a resolution plans. So OTS in this case, it was also observed that OTS given by the promoter as the resolution plan for withdrawal of the case. So it was also not considered, held that the CRP was not conducted in a fairness and diligent manner, as he compromised his independence and vitiated the entire CRP. So it is IBBA has cancelled and debarred the registration of him. In this case, Sanjay Trips Private Limited, it was RP was guilty of various acts in professional conduct, such as quoting fees based on old annual returns to fix his professional fee reflects gross negligence, and he has claimed travel expenses beyond the permissible limit and signed the term sheet with the operational creditor who is not legally competent to appoint RP or fix his fee. And the RP has performed every action in order to extract maximum amount of fee contrary to his duties and professional standards as an IP.